Today at the National Press Club, Law Council President Pauline Wright. Australia's the only Western democracy not to have a Bill of Human Rights. With the global rise of nationalistic politics, the Law Council says Australia must renew its commitment to fundamental protections. Pauline Wright with today's address.
Good afternoon, ladies and gentlemen, and welcome to the National Press Club of Australia and today's Westpac address. My name is Sabra Lane. I'm the club's president. I'm also the presenter of the ABC radio program AM. Today, with me here on the stage, Pauline Wright, the president of the Australian Law Council, and with her is Stephen Keim SC, on the need for the federal government to adopt a Human Rights Act. If you're following us online, you'll find us on Twitter. Our user handle is @PressClub, AUST. Please join me in welcoming Pauline Wright.
Well, thanks very much, Sabra. It's an absolute pleasure to be here today. I'd like to begin by acknowledging the Ngunnawal people, traditional custodians of the land on which we gather today, and pay my respects to their elders, past and present. I also acknowledge their youth, in whose hands is held our hope as a nation for a reconciled future. And I extend that respect to all Aboriginal and Torres Strait Islander people here today. This vast continent of Australia is privileged to be home to the oldest cultures on the planet. I'm delighted to be joined here today by Stephen Keim, a highly esteemed national expert in human rights law, who generously volunteers on Law Council's National Human Rights Committee, who'll share his keen insights on the policy being addressed here today. 2020 has been a year where we've all been faced with extraordinary challenges and sacrifices. We've faced storms of all kinds, fires, floods, and of course, the COVID-19 pandemic. Some people have lost their livelihoods, other people have lost their lives. But Australians have pulled together to weather these crises, and now national attention is turning to rebuilding our economy. Lawyers whose practical advice and expertise is critical to helping Australians stay on their feet through such crises will play their part in this rebuilding effort. We at the Law Council consider that this moment presents a unique opportunity for Australians to broaden the conversation on survival. Being prosperous is one thing, but how do we as a society uphold and enshrine our core democratic values of freedom, fairness and equality before the law? This is why now is the time to reignite the national conversation on a federal human rights charter, an issue which is bigger than any single government or political party. And while on the one hand we can be proud of the collective efforts of Australians to combat the COVID-19 pandemic, we must be careful to avoid an erosion of the rights and freedoms that my father and his generation and his parents' generation fought for, and that many Australians have had the luxury of taking for granted. Consider the recent criminal prosecution of whistleblower witness K and the trial of Bernard Collaery. Threats to press freedoms evident in raids on the homes of journalists and media organisations. New legislation giving the government sweeping powers, enabling unprecedented, yes, that word, encroachments on Australians' right to privacy. And technology companies facing an environment of enforced surveillance, with legislation enacted requiring IT companies to hand over user information, even if it's encrypted. At a time of global power shifts, increasingly fragmented and insular national politics, and events characterised as profound blows to fundamental freedoms being played out across the globe, the Law Council believes it's time to consider a renewed commitment to the fundamental, universal norms of human rights, born out of the horrors of World War II. As you'd expect of a mob of lawyers, the Law Council looks to the legal infrastructure that we have in place to pass on to future generations, not only the economic infrastructure. That brings us to the fact that Australia is the only Western democracy without some form of Charter of Rights at the national level, whether legislated by Parliament or constitutionally enshrined. Today, I am proud to announce the Law Council's refreshed policy on a Federal Human Rights Act. Our earlier policy is now 12 years old, and in the intervening period, there have been significant political, legal and policy developments that necessitate its review. The refreshed policy promotes a legislative model of human rights protection as a first step to achieving a constitutional model. It's the Law Council's long-standing position that guarantees of human rights should be included in the Commonwealth Constitution, thus assuring the most effective protection against legislative incursions into those rights. However, the policy put forward today is a pragmatic acceptance that a Federal Human Rights Act is the most feasible way forward in the first instance. The statutory model allays some fears about entrenched bills of rights, unchangeable and in the hands of unelected judges, as opposed to elected representatives, making it clear that elected legislators have the last say on broad policy issues. In Australia, 2 states and 1 territory have now enacted a Human Rights Act. The Australian Capital Territory, Victorian and New Queensland charters primarily guarantee civil and political rights, including cultural rights, embracing the distinctive rights of Indigenous peoples. Some jurisdictions extend to protecting certain economic, social and cultural rights, such as the rights to education, as included in the ACT in Queensland, the right to work, ACT, and the right to access health services without discrimination, and not to be denied access to emergency medical care, Queensland. These jurisdictions give us insight into how such legislation works in practice. While Queensland's legislation is relatively new, the ACT's statute has been in place for 16 years and Victoria's for 12 years. We can also look to comparable jurisdictions overseas, such as the United Kingdom, Canada and New Zealand, and draw from the lessons learned there so far. So why call for a Federal Human Rights Act? Let's look at 2 scenarios which we believe illustrate the need for a Federal Human Rights Act. Firstly, the COVID-19 pandemic, which has engaged multiple human rights in many different dimensions in Australia, from lockdowns to travel restrictions to tracing apps to mandatory quarantine and emergency health plans. Many Australians believe that their rights are already protected, that we already have a Bill of Rights similar to that in the United States. But in truth, our Constitution protects very few rights, and Australians would be surprised to learn that the rights which have been so hotly debated during the pandemic are in fact backed by few constitutional or statutory guarantees. And currently, there is a disconnect between Australia's obligations under international law and their translation into Australian domestic legislation, which is where they become enforceable. Take one example, the quarantining arrangements. These interfere with rights recognised under international law, such as the rights to freedom of movement, security of the person and freedom from arbitrary detention, and the right to non-interference with privacy, family or the home. At the same time, these measures are intended to preserve other rights, such as the right to life, the right to the highest attainable standard of physical and mental health. But many of these rights are not currently protected, and our current federal legal framework of protection is very limited and it's fragmented. Against this backdrop, who can blame individuals for becoming confused? The pandemic illustrated a need for a greater understanding that multiple rights may be at play in any given situation, and that tensions can and do arise between conflicting rights, which must be resolved. A Charter of Rights would help to do that. Specific rights are sometimes asserted by members of one part of the community to the detriment of the rights of others. For instance, Some may say that the requirement for quarantining following travel infringes their right of movement or freedom from arbitrary detention. However, there may not always be a full appreciation that the broader community has, under international instruments, rights to health and life, which governments and lawmakers are obliged to respect, protect and enable. A human rights charter may assist public acceptance of government decision-making processes, including for decisions which must be made against rapidly unfolding circumstances. It would provide a much-needed, established framework setting out the core principles to resolve tensions which arise when rights come into conflict. That's one scenario. Another is the spate of much-needed royal commissions established by successive governments. They've been called in response to, and have confirmed in graphic detail, a series of systemic and sometimes harrowing breaches of the human rights of diverse groups of Australians. There remains an urgent need to address the evidence received by and the findings of these commissions. They include the Royal Commissions into aged care, quality and safety, into violence, abuse, neglect and exploitation of people with disability, into the protection and detention of children in the Northern Territory, to name a few. They've revealed stories of children in detention being stripped naked, put into spit hoods and solitary confinement, aged care residents subject to shocking levels of neglect and the widespread use of restrictive practices in group homes for people with disability. Instances where preventive safeguards were inadequate, absent, or simply not observed. Each of these royal commissions, while welcome and necessary, has been reactive, crisis-driven and highly resource-intensive. Further, as we all know, the recommendations of royal commissions are not always implemented fully or even to a substantial degree. We need look no further than the largely ignored recommendations of the Royal Commission into Aboriginal deaths in custody. The result? New data in June 2020 disclosed that 434 Aboriginal people had died in custody since the report was released in 1991. And while Royal Commissions will always provide an essential policy tool when responding to urgent and complex situations, the Law Council considers that having a Federal Human Rights Act would provide an excellent preventative measure. We're not suggesting that a Human Rights Act is an instant cure to all social ills. However, a human rights ethos established across the public and private sectors, across aged care, disability services, childcare, education, health and detention facilities, may curb the systemic need for what can seem like almost rolling royal commissions investigating complex, wide-ranging social justice failures in Australia. I'll now ask Stephen Keim SC to introduce the new policy to you.
Thank you, Pauline. As has been previously mentioned, Australia is the only Western democracy not to have a Human Rights Act or some form of broad statutory or constitutional human rights protection. Countries with whose political systems we tend to identify most closely, such as Canada, New Zealand and the United Kingdom, all have some such form of established human rights protection and an associated jurisprudence upon which Australian courts already draw. It is always difficult to know where to start and where to finish with the history of international human rights instruments. Suffice to say that Australia played a big role leading up to the adoption by the General Assembly of the United Nations of the Universal Declaration of Human Rights on the 10th of December 1948. We ratified the two major covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights way back in 1980. On the international stage, Australia has taken a leading role. It is only at home that we seem to drag our feet. The promises we made in that process are encapsulated in the words of Article 2 of the International Covenant on Civil and Political Rights. We undertake to respect and to ensure to all individuals within our territory and subject to our jurisdiction the rights recognised in this covenant, without distinction of any kind, such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. A solemn promise like that should be honoured, and the Human Rights Act sought by the Law Council's policy would be a major advance towards honouring and giving effect to, in a thoroughgoing way, Australia's international human rights obligations arising under the major instruments to which Australia is a party. The ACT, Victoria and Queensland have paved the way. Federal legislation to give effect to Australia's international obligations can draw upon, but not be limited by, the experience gained in these domestic jurisdictions and the other jurisdictions around the world. The Law Council's revised policy covers the following 8 areas, and I'll say a word or two about them in turn. They are the rights to be protected, who should receive protection, the importance of an interpretive clause, statements of compatibility, duties on public authorities, an independent direct right of action, remedies, and procedure, including and especially costs provisions. The rights to be protected. As we now have experience of human rights legislation operating in Australian jurisdictions, the policy looks to broader sources of rights to be protected, not just the civil and political rights in the ICCPR. Greater recourse is urged to the economic and social rights, the rights of people with disability, the rights of children as identified in the more specialised international conventions on people with disabilities and on children, and also the rights of older persons, on which a covenant is still a work in progress. It seems fairly uncontroversial, the next heading, who should receive protection. It seems fairly uncontroversial that human rights protect the rights of human beings, not those of corporations. This does not mean that a tradesperson who conducts their business using a trust or corporate structure would not receive protection from an egregious assault on their rights. The importance of an interpretive clause. General legislative provisions have the potential to operate fairly when applied to specific fact situations. This is something of which the general law is conscious and against which it seeks to guard. A provision in a human rights statute that instructs the courts, as far as reasonably possible, to interpret all legislation past and future in a manner that is consistent with, or most consistent with, human rights, will strengthen the ability of courts to avoid unjust applications of the law. Statement of compatibility. The requirement that draft legislation be accompanied by more robust statements of compatibility, if implemented in good spirit, is likely to lead to legislation that is better considered and ultimately to better legislation. Parliaments are required, as part of regulating society, to limit the exercise of various human rights. Indeed, laws restrict human rights to protect human rights. A statement of compatibility process, especially when combined with a strong parliamentary committee process, is directed to ensure that drafters of such legislation use a human rights focus to give consideration to the precise objectives being pursued and to whether those objectives can be achieved in a different way with less draconian impacts on people's human rights. Ultimately, statements of compatibility seek to ensure that the legislation passed by our parliaments represents the best possible version of such legislation, especially from a human rights point of view. There is a process in place at the moment for statements of compatibility and for committee oversight, but we think it can be improved. Duties on public authorities. A Human Rights Act should include explicit duties on public authorities to act compatibly with human rights and to give proper consideration to human rights in the development of policy and the making of decisions. This is one of the most beneficial roles of human rights legislation. It is not doubted that public servants and public servant agencies are dedicated to excellent and just administration, but a duty to consider and to comply with human rights provides a touchstone against which every decision and practice can be measured. It also allows members of the public and advocates for vulnerable people a reference point by which questionable decisions and practices can be called to account, and the presence of an enforceable duty on public authorities, like any other enforceable duty, tends to focus the mind. An independent direct right of action. This should not be controversial, but my home state, Queensland, went with the so-called piggyback provision, such that a human rights basis for relief can only be pursued if a general law basis is also being pursued. That does not make a lot of sense to me and may add unnecessary complexity to some litigation. The experience with human rights-based litigation around the world is that fear of floodgates have not been warranted in practice. The Law Council believes that barriers to raising human rights concerns in court should be minimised so that vulnerable people are not prevented from seeking a remedy for what they see as an injustice. The ACT Human Rights Act in Section 40C does provide for a standalone right to sue for breaches of one's human rights under that legislation. That's the kind of approach that the Law Council supports. Remedies. The Law Council considers that in every case, an effective remedy should be available to provide appropriate and adequate reparation for the injustice suffered. Some jurisdictions have been cautious and, for example, have ruled out money damages as an available remedy. It is true that righting the wrong with a declaration and/or an injunction will be sufficient in many cases, but there will be other cases where a complainant has suffered greatly and many years of their life have been affected. They should not be denied monetary compensation. And procedural matters, costs. Cost regimes in human rights legislation raise several competing considerations. On the one hand, the threat of losing one's house and other assets because of losing what seems to be a fairly meritorious case will inhibit people's willingness to pursue their rights. On the other hand, the availability of a favourable costs order for a successful applicant will allow actions to be brought with the assistance of lawyers who are prepared to take a risk. The Law Council recommends a variety of approaches, including a less stringent costs follow the event rule to protect unsuccessful applicants, the availability of protective costs orders made early in the proceedings, which allow applicants to know that they will not be saddled with the horrendous legal bill involving the cost of 3 prominent senior counsel acting for the government, and an ability for successful applicants to receive compensation for the costs they have incurred in bringing the litigation. So there you have it. It's my pleasure to hand you back to Pauline. Thanks.
Well, thanks very much, Stephen. Naysayers will claim there are considerable negatives for enacting a Federal Human Rights Act. The cost to taxpayers, for one, or pressures on an already stretched court system, for another. However, the Law Council does not consider that the experience to date bears this out. Reviews of the operation of existing state and territory human rights acts indicate that rather than resulting in a lawyer's picnic, the benefits often lie outside court proceedings, and that human rights are considered by the executive and legislature early in their processes. It may in fact be costly for taxpayers not to promote human rights protection. For instance, last year, the Law Council noted reports that the Royal Commission into Aged Care would cost $104 million over 4 years. The Royal Commission into Institutional Responses to Child Sexual Abuse had cost about $500 million. The Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability would cost $528 million over 5 years, and the Royal Commission into the Protection and Detention of Children in the Northern Territory had cost around $54 million. I mentioned that a federal Human Rights Act will not cure all ills, but when we're being asked to tighten our fiscal belts, more cost-effective, preventative solutions are what we should be looking for, resulting not only in cost savings, but also in less personal heartache to many in the Australian community. Let's look at what is working at the moment. Of the 2 states and 1 territory that have a Charter of Human Rights, reviews indicate that the courts in the ACT and Victoria have been not flooded with litigation. Instead, there's been an improved parliamentary and bureaucratic culture of respect for human rights in a preventative sense. The 5-year review of the ACT Act found its main effect had been on the legislature and executive. It's fostered a lively human rights culture within government, leading to human rights concerns being given due consideration in the framing of new legislation and policy. These improved laws are likely to have tangible benefits over the longer term, particularly in the form of additional safeguards for vulnerable individuals in the community. Meanwhile, in Victoria, the Charter has played a crucial role in preventing or curbing many human rights breaches and their associated social and economic costs. The experience of jurisdictions with Human Rights Acts in place indicate that these have led to tangible and practical improvements in the way that people's rights are upheld in practice. These range from successfully challenging the use of restraints on a sick older woman in distress, to moving a 40-year-old man with disability from aged care into more appropriate care, to delaying evictions for older people until alternative accommodation can be found, to stopping the transfer of children into adult prisons. These improvements have been frequently negotiated at an early stage with bureaucrats and policymakers rather than through the courts. Such experiences underline the potential of a federal Human Rights Act in driving a government-wide culture of respect for human rights. But, I hear you ask, will legislating rights and freedoms help ensure that all persons are treated fairly and equally with dignity and respect? We know that few Australians are aware of the reality about the lack of protection of their human rights, and it's difficult for people to defend their rights when they know little about them in the first place. For human rights to have any practical effect, they must be incorporated in the education and practice of everyone in the Australian community. This includes, for example, teachers, the police, health workers, prison and detention facility operators, disability and aged care providers, business leaders, and the media. The Law Council is also concerned that there's a lack of human rights engagement and training across public departments and processes more generally. This may result in human rights not being properly considered when cabinet decisions are made, laws are designed, and policies and programs are implemented. Too often, human rights compatibility statements, which are often lacking in substance and quality, are tacked on at the end of the process rather than being baked in at the beginning. This lack of early consideration may mean that the needs of diverse groups within the Australian community are consistently overlooked. One recent example provided in evidence given to the recent Royal Commission was that people with disability were not mentioned in the Australian government's original pandemic emergency health plan. While this was later rectified, it was an extraordinary omission. Human rights should never be an afterthought They should be part of the democratic recipe. A well-drafted Federal Human Rights Act would, in the Law Council's view, help ensure that the needs and circumstances of people in Australia in all their diversity are better understood and reflected in policy and program design up front, whether in emergencies or in ordinary life. It would embed a general and fundamental understanding across the Australian community that all persons are of equal dignity and worth, with human rights which must be respected, protected and fulfilled. I think we can all agree that 2020 has been a year that many of us would rather forget. Australians have been challenged by unprecedented, and they have been unprecedented, restrictions to their liberties. It's not my place to comment on what the most appropriate measures should have been during the pandemic or what should be taken in the future, except to say that Australia has continued and will continue to have international human rights law obligations throughout this challenging period and beyond. Any restrictions on the enjoyment of rights imposed as a result of the pandemic must be justified by reference to the standard framework within which such questions ought to be considered. Some limitations of rights may be needed, but any such limitation must be necessary, reasonable and proportionate to a legitimate purpose, and never to those fundamental rights which are immutable. The COVID-19 pandemic is not, of course, the only national emergency that Australia will face. Moreover, history tells us that in times of crisis, human rights are peculiarly vulnerable to serious infringement. We do need to remain vigilant to ensure that measures taken in crisis are temporary and do not endure beyond the tail of the crisis. We do need the tools to guard against overreach. A Federal Human Rights Act would be a powerful tool to build the edifice of Australia's international human rights obligations. It would ensure that the decisions and actions of our governments are guided by the time-honoured values of freedom, equality, justice, compassion and dignity. It will help everyone, from school children to recent arrivals, including those fleeing from war and terror, to understand the rights and freedoms that we all share and to place a premium on them for the future. It will mean that questions of human dignity are taken into account when they matter most. We are at a turning point in Australian history as we look past 2020. Now is the time for conversations between the Australian people and their governments. What kind of future do we envisage for coming generations? How can we be a prosperous and a just and fair community? A Federal Human Rights Act may not be a complete answer, but it's a start. So I ask this question: what are we afraid of? Thank you.
Thank you for that. I've got a question for each of you. Presumably, if there is a Federal Human Rights Act, would that override the existing state and territory human rights laws? And Stephen, a question for you, and I don't know whether you'd have the answer to it, but I'm asking you because you are Queensland-based. The family that had been living in Biloela, the Sri Lankan family, Nada's Priya and their two children, they were taken from their home in Biloela and put in detention in Melbourne, I think in 2018. They're still on Christmas Island. Would a Federal Human Rights Act be protective of them in any way? Could they seek, would that have prevented that situation?
The detention is authorised by specific legislation. So by passing the Human Rights Act, you don't simply repeal those laws, but there would be an obligation on the courts to construe the legislation under which those actions are taken in a way which is most compatible with human rights. And so it may be the case, and I haven't looked at this specifically, it may be the case that the decision being made pursuant to those laws is not a decision in accordance with those human rights, or that the legislation can be read down in some way to say that so it's a vexed question. But it's probably also good to explain, although even this is not a good example, that it doesn't prevent, for example, governments dealing with the problems of terrorism, because what you have in, for example, evaluating a government decision, you look at the objective that is being pursued, you look at the nature of the human right that is being limited, and then you balance that in a process to say whether that's a reasonable limitation on those rights in a democratic society. So, and one of the factors taken into account in that regard, are there less draconian alternatives? Can you achieve the objective? Is it directed to achieve the objective? But can you also achieve the objective in a way that doesn't have the same impact on human rights? So in terms of asylum seeker legislation and decisions made under the Migration Act, that does have a potential to say, well, can we achieve the security that we're trying to achieve without locking up every refugee, every person who's seeking asylum in Australia? So there is a potential for operation in that area, but I don't want to give you any kind of fake definitive answers. Thank you. And what was your question, Pauline?
Yeah. The question is, would a federal act override the existing state and territory acts?
No, not necessarily. There may be, where the state and territory acts conflicted with the federal one may override those particular provisions, but in general, no, they could operate side by side.
The policy operates on the basis that it's really directed at Commonwealth law, directed at Commonwealth agencies. But of course it is possible for a Commonwealth government to use the external affairs power to legislate much more broadly with regard to human rights, and the Disability Discrimination Act and the Sex Discrimination Act and the Race Discrimination Act do apply across the board. And you'll remember that that native title was saved because the Queensland legislation seeking to abrogate native title in Queensland was found to be in conflict with the Race Discrimination Act. So the Commonwealth Government has the power, but the focus of the Law Council policy is really getting the Commonwealth's own house in order rather than creating a federalism dispute in the country at this point in time.
First question, Andrew Tillett.
Thanks, Sabra. Andrew Tillett from the Financial Review. Pauline, we're often told, justice delayed is justice denied. We're going to get tomorrow the Brereton inquiry into misconduct and potential war crimes committed by Special Forces soldiers, Australian Special Forces in Afghanistan. I was just wondering, it's been taken 4 years to reach this point. The government's going to appoint a special investigator who then maybe bring these cases to trial, which a process that some observers could take up to a decade. I was just wondering if you think we're in a situation where this is going to be unacceptable from the point of view of soldiers who are accused of war crimes, but may have to wait potentially years for their day in court and live with the uncertainty over that. And conversely, given the complexity of some of these allegations, will there be soldiers who effectively get away with it? I was just wondering if the council's got some sort of maybe some principles for what this is going to be, given the potential for it to become a lawyer's picnic.
Look, you're absolutely right that justice delayed is justice denied. And if people are being accused of war crimes, which is a very serious thing to be hanging over one's head, the obligation of the government to ensure that that process is dealt with in a timely way has to be foremost. They must deal with it quickly. It's, at the same time, essential that the investigation process be thorough and fair. Not only for the victims of the alleged war crimes, but also for the people accused. It's got to be a fair process. It's got to be thoroughly investigated. So the government is going to have to come up with a process that is both fair and timely.
Andrew, your question also reflects on Pauline's point about the Royal Commissions as well. Often we have a Royal Commission because people complain, journalists investigate matters, but governments just ignore the problem as much as they can. And governments are really good at ignoring problems. What a Human Rights Act tends to do, and we've seen this in some of the examples that Pauline gave about vulnerable people in nursing homes being able to get a remedy, is it gives people a remedy. And so if you have something wrong, if you have a person who's 40 years of age and locked up with people or maintained in a residential facility where everybody else is 95, then your representative, your advocate, can take a step. And if the government doesn't respond, if the department doesn't respond, you can then make a complaint and litigate the matter. So one of the things about this is where there are even sometimes quite unintended injustices occurring, the fact that a person has got a remedy and it can go further will often make public servants and politicians react more quickly. So it wouldn't necessarily have worked with regard to the war crime allegations, but in very many areas of Australian society, the delays that you're talking about don't have to build up into eventually a Royal Commission if you have that kind of test, that set of criteria which departments and laws have to comply with.
Thank you.
It's a follow-up question, and it's a really tricky question. There will be a lot of attention on this report tomorrow and the alleged crimes. What about the victims and their families of these crimes in Afghanistan? What should the government be thinking and doing about that issue?
I'll leave that to you, Pauline.
Well, I think that dealing with it in a timely way is one of the most important things that they can do, because those families want to believe that their complaints are being heard, are being thoroughly investigated, and are being done promptly, because otherwise that sense of injustice hangs over those people and creates a worse climate globally. So we don't want Australian troops to be being accused of these things with those sorts of allegations being made and unresolved. So the timely resolution of it is fundamental to proper treatment.
Daniel Hurst.
Daniel Hurst from Guardian Australia. Just a quick follow-up on that. First of all, do you think the Australian government has an obligation or duty to provide some sort of comprehensive redress or compensation scheme for the families of those victims in Afghanistan? And secondly, you recently criticised the increase in federal circuit court fees for migration cases. You've described them as unconscionable and exorbitant. Can you sort of give us a sense of what your fears are of the practical impact of those increase in fees for migration cases?
Thanks, Daniel. Yes, in terms of compensation, I think that if after the investigation concludes and charges are brought and convictions are recorded, then it is incumbent upon our government to have some kind of compensation scheme. That is presupposing that convictions are in fact secured at the end. It may well be that there are not, but we can't know that at this point. But certainly if after the investigation there are convictions, then the government should certainly be looking at that. In terms of the Federal Circuit Court fee increase for migration matters, what that means for people, an increase from $300 and something up to $3,000 and something. I don't quote me on the figures, but it's an enormous increase that they're facing. That is going to be an impost on those people where in the Australian community often they're not allowed to work. They don't have working visas. They don't have an income. They're not entitled to support. So they don't have money, and that will make it almost impossible for a lot of people to even bring an application. It'll also mean that a lot more people who might be able to scrape up the money for the application fee can't afford representation. That will mean that delays in the courts become even worse than they are now and puts more work on the judges in the federal circuit courts who are already overloaded, critically overloaded. So it's going to create delays, it's going to mean less people are able to bring applications, and it really is a mistake, and I think it's something that the government ought to reconsider.
Talking about delays, there's been some attention recently on the Family Court of Australia and the extraordinary delays that are happening there. Is change happening there quickly enough? Is the government addressing that quickly enough?
Well, the government is proposing some changes, Sabra, but the change that they're proposing, I think, is not the right one. They're proposing to effectively do away with a standalone Family Court of Australia and bringing all the family court matters into the Federal Circuit Court, where you've got judges who are already grossly overworked. Some judges are sitting on 600 docket cases at any given time, and most of them around about 300 to 400, and it's just too much work. And how disbanding a specialist standalone court with wraparound services for mediation, counselling, and welfare built in, how disbanding that is a good idea, I can't see, and it's certainly not going to help delays.
Lani Scarr.
Lani Scarr from the West Australian. I want to ask you both in relation to the allegations that were aired against Attorney General Christian Porter on the ABC. I assume neither of you are going to talk about the specifics of that case, but I want to know, as the nation's first law officer, whether the Attorney General does need to adhere to a higher standard than many other politicians.
Look, I think that anyone in a position of power, and that includes lawyers and people who have high status jobs and are in the public eye, do have a higher duty to behave in a way that the rest of the community sees as being behaviour of integrity. And I think that that is incumbent on all of us to behave in that way. And that's why the Law Council has long been calling for a Federal Integrity Commission to look at broader questions about the behaviour of our politicians and people in the public sector, as well as law enforcement. And these things are really important to Australians, I think, to see that if there is an allegation made, that can be properly investigated, that person against whom the allegation is made has a fair chance of defending themselves and having their say and denying it, as has occurred in this case. There needs to be a fair process and a transparent process, and that's why we've been calling for a Federal Integrity Commission. I think it's really important that we have one.
Tim Shaw.
Thank you, Sabra, and thank you both for being here today. Tim Shaw, Director of the National Press Club. I guess with good heart and good intent, legislators and the executives go to their houses, their assemblies, and they vote on laws. Until we see what you've outlined today, what first principles do you want every federal member of Parliament to apply when in their party rooms they're being asked to vote on these matters of legislation? Very often we hear from the Federal Attorney General and many other Attorneys General, the legislation already exists. And that's what the layperson watching today understands, that there are protections for them. So in that first part, what would you ask today's electors or elected officials to be able to apply on those first principles?
Thanks very much, Tim. I think that what we want to see is our policy makers, our legislation makers, to be doing for us is to be saying, what will this law do? Does it protect people's dignity, their human dignity and right to respect and right to fairness and right to equality before the law? Does it guarantee those things for all people in Australia? And if they're thinking through that lens, we're going to have better laws.
Steph?
Yeah, I think there's a couple of things that come out of your question, Tim. One of them is that and the examples that Pauline gave in her speech, having a human rights structure doesn't necessarily prevent governments and legislatures from achieving really important objectives. And the point that Pauline was making with regard to the pandemic is that many people felt, in fact I think most people felt, particularly Victorians felt, that the restrictions that were being done were not a restriction of their human rights, because they were seeking to achieve something that was also really important, namely the health of the population and the health of the individuals. So, but there were other people who thought, I've got human rights to do anything I like, no matter what implications it has on other people. And what the structure of human rights legislation does is it says, well, you start with the objective, you look at the means that's seeking to achieve that objective. Are there alternatives to those means which would still achieve the objective but have less impact on people's rights? And I mean, the really dramatic areas such as preventing terrorism and preventing a pandemic bring up those issues. Namely, you can panic as a legislator. You can introduce incredibly draconian laws because you say they're justified by this threat that we have. But if you have a proper process, those sorts of disputes can ultimately be arbitrated. You can look at what has been done, and you can say at the end of the day that went too far, there were lesser alternatives which were available. From the point of view of the legislator, if you bring those considerations up front, if legislators really take their compatibility statements seriously, if they actually give time to the parliamentary committees to judge the legislation against the principles of human rights, then you get better legislation. It's not that you are prevented from dealing with the problems, but you deal with the problems and you have better results for the community as a whole. And in terms of, you've said what the legislators say, we've already got those laws in place. What a lot of Australians say is, I'm going to rely on the Fifth Amendment. So a lot of us, or I'm going to rely on my Miranda rights.
Yes.
So a lot of Australians actually assume that we have these protections in place. And when they watch a program like this, they get surprised. Or when they are required to wear a mask, they get surprised. They say, aren't all my human rights already protected? So I think the process and having those structures in place will do what a lot of people expect of their laws. It will assist politicians and public servants and public entities to achieve their objectives, but achieve their objectives in a way that doesn't lead to problems. I mean, no public service department wants to detain a person or look after a person who's 40 years of age but suffering from a disability, requiring being looked after, with 90-year-olds. But it just slips through the process. I mean, the very word bureaucratic speaks of those sorts of problems occurring. We want to be able to have remedies so people can address those problems and get them addressed by the public servants up front. Thanks.
Now, while we've been on air, the South Australian Government has announced a hard 6-day lockdown from tonight. All schools will be shut. Pubs, clubs, restaurants, food courts, everything will close. Real estate openings won't go ahead. Weddings and funerals are cancelled for the next 6 days to clamp down on what's happening in South Australia. It's to try and stop another Victoria happening. There will be a cohort who say this is an infringement on my rights and my freedom of movement. What's your response to, the lockdowns that we've been seeing happening here and the one that will happen tonight in South Australia?
Sabra, there's no doubt that it is a restriction on their movement. There is no doubting that. But the question is it a proportionate restriction on their movement given the threat of this pandemic? Up till now, I think that the vast majority of Australians have felt that the lockdowns and restrictions have been proportionate. Where it breaks down is potentially where the people start to think it's overreach, it's too much restriction given the threat. But this pandemic has shown itself to be deadly. And we do expect from our government's protection of our health and lives. And so most people are going to be satisfied that it is a reasonable restriction as long as it's temporary, doesn't last too long, and is proportionate to the threat that's still at large.
Do you want to add to that, Stephen?
It just so happens, because we have Section 92 in the Constitution, that Clive Palmer was able, and at one stage I think the Prime Minister was supporting him in this, was able to bring an action with regard to one aspect of the restrictions, which was the border closures. That went to the High Court. It was considered by the High Court, it was argued, and in the end it was found to be proportional. And a lot of the principles of proportionality, especially with regard to the implied right of free speech in the Constitution, the High Court has tended to adopt those sorts of principles from the overseas human rights jurisdictions in order to test whether the implied right to freedom of speech is being breached, but also whether the prescription that intercourse between the states shall be absolutely free is being breached by a restriction in the time of pandemic. The High Court found that it wasn't. With regard to the broader areas, if you had human rights legislation in South Australia, if people thought that the government was going too far, they would have a right to test that in the courts. At the moment, they probably don't.
Nick Stewart.
It's a brilliant idea. I can't imagine any political party going to the next election saying, we don't believe in human rights. So what are you doing to actually get the political parties on board? Everyone knows human rights lawyers in particular have oodles of time that they'd be willing to devote pro bono, I'm sure, to establishing this. Are you going to develop a Bill of Rights, a law rather, to incorporate those rights that can be taken by Labor and Liberal to the next election to say, right, vote for us and we will actually legislate this? But on the other hand, you mentioned Section 92, also, aren't we better just, and this is the statist approach, leaving it exactly the way it is, because we trust the courts, supposedly. We trust the courts to actually implement, we've already signed up to these international treaties. Why do we need to incorporate them as a simple law when we've already got the international treaties and courts can also take precedent from overseas? Why do we need anything more? Why do we need another question, in other words, for anyone intending to come to Australia, which asks them to detail rights that they may have acquired by becoming an Australian citizen, rather than something really important like Don Bradman's batting ad for average?
Thanks, Stuart. What the Law Council is doing in relation to persuading our politicians that we need a Charter of Rights federally is starting the conversation as of today. This is step one, having an event like this and promulgating our policy. Because bringing in a law like this requires a conversation with the people of Australia. And it's not a question of coming up with a form of words that the Law Council thinks is good, although we will be very happy to assist in coming up with ideas. But we do have to make sure that the Australian people want this, are comfortable with this, and that our Bill of Rights is something that speaks to us as a nation, that deals with the things that Australians want it to deal with. And so it's a start of a conversation, but we do need it to happen, and we'll be calling on our politicians of all parties to consider it and get it moving.
Thank you.
Steve Lewis.
Thank you. Steve Lewis, Director of the Press Club. Very hard to follow on from my learned friend, but let me give it a go. A serious question about this little device. Would a Human Rights Act, a Bill of Rights, would it do anything to deal with the encroachment of big data, big tech on individuals? I mean, I think a lot of people would say that the fact that Facebook, Google seems to know more about their personal lives and their family is an invasion of human rights. Would a Bill of Rights have any impact on the encroachment of big tech?
Well, it would have an effect with regard to the writing and passing of legislation by the Commonwealth Government. The issue of privacy is so many faceted, and a lot of these things happen in the private sphere that wouldn't necessarily be regulated or necessarily be challenged by the Human Rights Act itself. And there's a lot of work being done all the time into the requirements to deal with the threat of big data. But what it would do, for example, are some of the amendments to the telecommunications legislation, some of the requirement of bodies to keep data, the accessing of data by Commonwealth law enforcement institutions and national security institutions, intelligence institutions. Those sorts of decisions and that sort of legislation would be subject to the sort of analysis that I've explained, which is what is the objective that you're trying to achieve? Are there less draconian ways in terms of people's privacy in achieving those objectives? Is that the sort of legislation that is appropriate in a democratic country? What is the balance between what you're trying to achieve and the human rights that you're impacting upon? So I think it does have an important role to play. I mean, the right to a family, the right to family life, there's sorts of things in which have been used to address privacy issues in various jurisdictions overseas. I think it does have a role to play in the privacy area, but the privacy area is so complicated. There are so many threats to our privacy that's why we've got privacy commissions. They deserve more money and more resources to advise us with regard to those issues. Thanks.
Andrew Tillett.
Thank you again. Just following on sort of from Sabra's sort of point earlier about Adelaide, and one of my colleagues pointed out that the reason they can't do exercise in Adelaide in South Australia is because they don't have a Human Rights Act, whereas in Victoria they were allowed there 1 hour a day because they do have a Human Rights Act. So I guess we've sort of proved your argument there. Thanks very much, Stephen Marshall. And sort of following on also from Nick's point as well about the politicians, but what about the public? I mean, the thing that I've sort of noticed with this pandemic, I think, is just how sheep-like some Australians have been in going, you know, along with these restrictions. Like in Victoria, you know, it seems it was a majority of support for it. We've seen with other things too, with like the national security laws that have been passed in recent years, Australians have just sort of gone along with that, even though there's been an erosion of civil liberties there. It seems to me that there is just really no appetite at all for some sort of human rights law among the public, let alone the politicians. How do you sort of get that case, given what you say, that a lot of people don't even know we have these rights guaranteed, these rights aren't guaranteed? How do we sort of build that case publicly and get that groundswell to make it happen?
I think it's a good question, Andrew, because Australians do have a lack of understanding of the rights framework within Australia. They do think we have rights protected that we don't have protected. Australians also, the data shows, are quite compliant to regulation. Australians like being regulated, they like rules, and they, you know, if something goes wrong, they say, there ought to be a law against that. And that is the way that Australians behave. So there's no surprise that Australians have been fairly compliant with the restrictions that have been placed on them through the pandemic. Because I think that in some ways, we can be proud of that, because people have been behaving as a collective and saying, we want to protect other Australians and ourselves against this disease, so we will do this. But that social compact will break down if the government takes it too far. It will break down. At the moment, it hasn't, apart from in certain pockets. But we need to, I think, be sure that the Australian people understand that a Human Rights Act would protect everyone against overreach by the state. It brings it back to a more level playing field. At the moment, the government has all the power and the people don't. So a Human Rights Act, if they understand it in that way, creates a more level playing field between the people and our governments. And I think that if we can communicate that message and to say that this guarantees us all the right to live in our society with dignity, with freedom, under compassionate government that's going to take into account who we are as Australians. And I think if we can communicate that, the Australian people will come along with us for this conversation and persuade our politicians that we need this Charter of Rights in Australia.
I think also that a lot of people did engage with the Brennan Review when it was conducted more than a decade ago. There were a huge number of submissions. Most of them were favourable with regard to the concept at that stage. We didn't get a Human Rights Act then, but we've had another decade of experience under the ACT in Victoria. I think the people in the ACT and the Victoria accept the legislation. I think people who are vulnerable and their advocates are aware of the rights that are offered. They do make challenges, people in public housing, people with disabilities, children in detention, a whole lot of groups of people who are particularly vulnerable are the people who are most protected against adverse government decisions because of this legislation. So I think the benefits are there. The sorts of examples that Pauline gave in her speech are really, really important. And if you take the Canadian example, they passed legislation in 1980 so that they had a legislated act. In 1960, and then in 1982, 22 years later, they said, let's whack it in the Constitution, and they have, and they now have a constitutional Charter of Rights. So there's a complexity to it, but I think when people hear discussion, when they engage in the discussion themselves, generally there is strong public support for this kind of legislation, and I think we can generate that kind of enthusiasm again.
Time for a quick question from Russell Miller.
Pauline, thank you for your excellent address, and you both make a very strong case in favour of the federal legislation you're proposing, so well done. I want to take you to one part of your presentation, Pauline. You talked about the Witness K case, and of course that's in the context of the fact that one of our basic human rights is a right to independent representation before the court, which takes us entirely to the Bernard Collaery prosecution here in the ACT, even though it has a Bill of Rights. Could you tell us a little more about what the Law Council's view is in relation to the principles that case is indicating and the way in which the Law Council is dealing with those principles?
Thanks very much, Russell. The Law Council has been very concerned about the laws that are in place that have allowed the trial of Bernard Collaery to take place in closed court. We've been very concerned about that. We've been attending every open session we can. One of our staff members has been there, I've been there. We've been observing, we've been going along as much as we can, but it's the law itself that is objectionable. How can the Australian people see that justice is being done if those proceedings are conducted in closed court? How can an accused person properly prepare their defence if they don't have access to all of the evidence that's being put against them? These are fundamental questions about how justice is done in Australia, and the case of Bernard Collaery is a glaring one, and we as a legal association are very concerned that one of our members is being subjected to a trial like that under that objectionable legislation.
Everybody, please join me in thanking our guests today, Pauline Wright and Stephen Keim.